Good morning. Your Excellency, honorable judges, dear colleagues, ladies and gentlemen. 2 years ago, the members of the ADC began discussing the needs and the importance of ICTY Legacy Conference from defense perspective. We were aware that we are approaching to the final days of the ICTY. The circle of the project that lasted for the several decades is almost closed, and the focus and the energy that creates and maintains the efforts of that project will diminish. The creation of ICTY as the first war crimes court created by the UN and the first international war crimes tribunal since the Nuremberg and Tokyo tribunals will certainly leave a significant mark in the legacy of international criminal and humanitarian law. Additionally, the development of the procedural and substantive law at the ICTY has informed, cautioned, and instructed the international community's involvement in armed conflict. And finally, and quite importantly, the tribunal's work had profound consequences, both intended and unintended, on the region of the ex-Yugoslavia politically, socially, and legally. Throughout these years, Defense Council and their teams were not mere spectators and decor in trial proceeding before the ICTY. We had important responsibility in a new mixed system of law that was unsure and uncomfortable with how best to proceed in the light of magnitude of the issue presented. That responsibility included establishing that the recognition and the respect for defense functions was critical to the validity and integrity of this emerging body of law. We have struggled to show that a fair trial can be possible only through acceptance and respect of defense as an equal party of proceeding. That only in conducting a fair trial is there a possibility that the work done here can be accepted and respected. And above all, that only in a fair trial we can achieve our main goal, professional representation of our clients. In performing our task, when we went through various experiences and shared them among ourselves, together with our worries, successes, and disappointments. Working with this ever-growing team of people dedicated to the proper and adequate defense for accused has been exciting, educational, challenging, sometimes humorous, but also sometimes tragic and painful. Coming to the end of this road, we believe that all we have done and what we went through cannot and must not be disregarded and needs to be shared with others who were not parts of our association. We believe that our experience are worthy to be shared primarily with international professional community and with those who will find themselves in our shoes in the future, responding to the future war. Because no matter how hard we want the word war to be deleted from the dictionary of modern civilization, wars remain our reality, and besides them, war crimes as an evil that follows each and every war. The concept of this conference entails speeches of our members, but also those who have had task of sitting in judgment. It's our pleasure to say that the president of ICTY, His Excellency Judge Meron, the former Judge Bonamy, and Honorable Judges Molotto and Morrison accepted our invitation to participate as speakers in this conference. We also want to hear the voice of those for whom this conference is taking place, young lawyers, future defense counsel, future judges, and prosecutors. So we organized this conference as a panel with interactive participation. I must underline that this is not our first public project, We are proud that we published Manual of International Defense ADC-ICTY developed practice. It is our immense pleasure to learn that this manual is used as a roadmap for Defense Council in trainings and in trials throughout the former Yugoslavia. Our intention is to issue a publication as an outcome of this conference that will facilitate spreading the information we share here to the professional public. I wish to express our gratitude to everybody who made this conference possible, to our colleagues who accepted our invitation to participate, to the many young volunteers and interns who contribute to the organization, and especially to our head of office, Ms. Isabel Duzerhoff. Our special gratitude goes to the Register of this Tribunal and OLAD, as well to Erasmus University from Rotterdam. We regret that many embassies, public and international institutions never replied to our multiplied requests for help in organization of this conference. Maybe in broader context that depict the image of Defense Council enjoy in society. As for us, we will remain the keepers of the flame, and we will keep it as a light for the road of the fair trial ahead. We will use it to fight misunderstanding and misapprehensions and prejudice so often present in and out of the courtroom. I underline this in the name of 600 legal assistants, case managers, interpreters, more than 200 investigators, 100 defense experts, without whom our mission could not exist. But I also underline this in the name of 220 consuls from more than 20 countries who worked before this tribunal, founded and were part of ADC-ICTY. Thank you. I'm calling now President Meron as a keynote speaker. Your Excellency, the floor is yours.
Thank you, Mr. Lukic, for your kind words of introduction. As some of you may know, I've just returned from several days in Bosnia. I have been at this incredibly painful site of the recent mass excavations in Tomasica. I went to the camp, or what remains of it, in Omarska, and I was in Prehidor to meet with representatives of Izmir and other victims groups, whom I have also met in Sarajevo. Nothing brings into relief the work that we are doing in the tribunal as much as seeing those, visiting the site of those unspeakable atrocities. And it was only through justice here at The Hague, to which you have contributed so much, that we can face those atrocities in a way looking not towards the past, but looking towards the future. Let me greet here Lord Bonomi, a very distinguished colleague of mine, who has made an incredible contribution at The Hague towards reforming our rules. He has served on several working groups on reforms, and we are all ever so grateful to him. And I am so pleased to see here my distinguished colleagues, Judge Sekule and Judge Ramarason, and I'm pleased to hear that other ICTY judges will participate in the program. So let me start, but before starting, let me apologize in advance. I will have to leave right after my speech because I have to go to the Security Council, to which I have to report next week. Excellencies, ladies and gentlemen, this past spring, on 25 May 2013, we marked an important milestone, the passage of 20 years since the establishment of the International Criminal Tribunal for former Yugoslavia by the United Nations Security Council in Resolution 827. In the months that have followed, we have commemorated this milestone here at The Hague and in the former Yugoslavia with exhibits, working level meetings and conferences. And I'm delighted to take part in this ADC-ICTY conference today, as it provides yet another opportunity for us all to reflect upon the legacy of the ICTY in this, the 20th year since its establishment. When the ICTY was created, of course, many had their doubts as to what it could or would accomplish, and whether the bold ideas embodied in Resolution 827 and reflected in the Tribunal Statute would become a reality. Over the years, the Tribunal has faced a number of challenges, both big and small. But as we gather here today, I am proud to report that the ICTY has put to rest the early doubts and achieved far more than many would have expected 2 decades ago. Indeed, many of the advancements made since 1993 in the world of international criminal justice were made possible thanks to the groundbreaking example set by the Tribunal, and when the Tribunal eventually closes its doors, as it will before long, it will leave behind an important legacy. In some respects, this legacy is quite tangible. As a result of its trials and thanks to the efforts of both the prosecution and the defense, the Tribunal has become the guardian of an extraordinary quantum of evidence and information concerning the events, the said events, during the conflicts in the former Yugoslavia. This unparalleled compilation of material will serve students and researchers for generations to come. Over the past 2 decades, the Tribunal has also crafted practical processes and procedures to address a wide range of responsibilities, including the enforcement of sentences, the transfer of accused persons across state borders, and the protection of victims and witnesses. As the first international criminal court of the modern era, the ICTY's advances in the relations to these and other key court management matters have served as valuable models for other international courts, and indeed for judiciaries and practitioners in national jurisdictions as well. These advances and the expertise the Tribunal and its staff have developed in making these policies and procedures operational are also an important part of our legacy. More fundamentally, the ICTY has demonstrated that it is possible to try even the most complex of cases involving allegations of some of the most horrible crimes imaginable and brought against senior military and political leaders, and to do so not once or twice, but time and time again. And of course, through hundreds of decisions and judgments, the ICTY has established key precedents in the area of international criminal and humanitarian law, precedents that clarify the scope of customary international law. Our rulings on matters of international criminal and humanitarian law have not only been applied in the Tribunal, but have informed the work of other international courts and of judicial authorities, military and political advisors, and practitioners in domestic jurisdictions. But this is not all of our Tribunal's legacy. Although the ICTY is a court mandated to try individuals for serious violations of international humanitarian law. In trying these cases, our court has also prided itself in having at its core a deep commitment to respect for human rights and for due process of law in particular, fair trial rights, such as the right to be presumed innocent until proven guilty, the right to a fair and public hearing, are not simply at the core of our statute. They are and continue to be a fundamental concern, the import of which informs how trials and appeals are conducted day in and day out, and the structure and myriad services provided by the registry of the tribunal. Fair trial rights are the focus of a great many of our decisions and judgments, and our rulings in this regard embrace a range of topics, from the sufficiency of an accused's notice of the nature and cause of the charge against him, to the adequacy of the time and facilities granted for the preparation of his defense, to the availability of translations of certain documents and judgments in a language that the accused can understand. My fellow judges and I have weighed such questions as the right of the accused, of an accused, to represent himself on appeal, the scope of the principle of the equality of arms, and the standard for establishing fitness to stand trial. In its 2001 appeal judgment in the Celibici case, for example, the ICTY's appeals chamber concluded that in the absence of express statutory safeguards and warnings, an accused's silence could not be considered in the determination of guilt or innocence. In the Furunzia appeal judgment, the appeal chamber considered the right to a reasoned opinion. And in a 2007 decision in Perlich, the tribunal weighed questions involving the admissibility and evaluation of evidence. In addressing these and other fair trial questions, we have turned time and again to the standards set by international human rights conventions, by the European Court of Human Rights, and by other key human rights bodies and instruments, weaving international human rights law not simply into the fabric of our own jurisprudence, but into the practical example we set for other international courts and tribunals and for courts in domestic jurisdictions. This centrality of human rights law and of fair trial principles to the work of our tribunal is undeniably an important advancement as compared with the approach of earlier courts, trying the accused of war crimes and other violations, such as the tribunals established at Nuremberg in the wake of the Second World War. To be sure, many may disagree with the outcome of individual decisions and judgments issued by the ICTY, but I believe that no matter one's view on individual rulings, it is abundantly clear that respect for fair trial rights and concern for the paramount importance of ensuring fair proceedings have been central to all that the tribunal has done over the course of the past 20 years. The evident centrality of fair trial guarantees and due process to our proceedings has been and will no doubt continue to be another vital part of our legacy, both for other international criminal courts and for courts in countries around the world. Why, one may ask, does this matter? Why is there such a focus on fair trial rights? It is because, to my mind, without a fair trial, without a fair process, there is neither justice nor accountability. This is true for any court of law worthy of its name. But given the high profile of the cases that come before our tribunal and the nature of the alleged crimes at issue, it is all the more important that we ensure that our proceedings are scrupulously fair and governed by the sober application of the law and the rigorous consideration of the evidence put before us. Ensuring the fairness of the proceedings is, of course, the responsibility of the judges of the tribunal, and it is a responsibility that my colleagues and I take very seriously. But judges are not the only ones who are guardians of the fairness of the tribunal's proceedings. The parties who appear before us, including both the prosecution and the defense, play an invaluable role in this regard. As you are no doubt aware, the tribunal's founding documents and rules reflect a combination of different legal traditions, but the tribunal's approach to matters of procedure was indisputably influenced early on by the common law adversarial system, even as its approach to evidentiary matters showed the impact of continental civil law traditions. Others may disagree, but to my mind, the tribunal and its proceedings have benefited tremendously from this adversarial structure and from the rigorous advocacy by all parties that it invites. Defense counsel appearing before the tribunal are indisputably vigorous advocates for their clients and their clients' interests, as they are ethically required to be, and the tribunal greatly benefits from this robust representation. The role of counsel in identifying and presenting careful, researched arguments concerning the potential violations of fair trial guarantees and of the law more generally is invaluable to the Chamber's own ability to consider and address these issues. The committed engagement and considerable efforts of defense counsel in service of their clients are thus crucial, not just to the functioning, but to the credibility of both the tribunal and its work. The part played by the prosecution is equally important. This is not simply because it falls to the prosecution to bring the cases that form the core of the tribunal's statutory mandate and to make cogent and careful submissions on all matter of issues before the chambers, just as the defense does. It is also because, as the tribunal's appeals chamber recognized more than 13 years ago, the prosecutor and his staff are, in essence, and I quote, ministers of justice assisting in the administration of justice, unquote, with all of the considerable responsibilities to ensure the fairness of the proceedings that this significant role entails. In sum, the tribunal's central focus on fair trial rights and due process of law represents one of the most significant innovations in international justice in the modern era. And if its precedents, both practical and jurisprudential, constitute one of the most significant aspects of the tribunal's legacy, as I believe they do, the tribunal's achievements in this regard are not the institutions alone. These achievements and this legacy are also due, and indeed they are thanks to, the efforts and dedication of the worthy advocates who come before the tribunal and the seriousness of purpose with which they approach the trials. I recognize that the role of counsel before a court is rarely easy, and that appearing before an international criminal court like ours may involve novel challenges, long hours, and a scope of work rarely, if ever, seen in domestic proceedings. Please know, however, that all of you in the audience who appear before the tribunal have my sincere admiration and respect for your dedication to your work, to the principles and laws that guide us, and to international justice. Your role in helping to ensure the tribunal's commitment to principles of fairness and due process have been critical to the ICTY's achievements in this respect. And for this, in particular, I salute you and I thank you. As we move forward with today's discussion of legacy, I hope that all of you know that the tribunal's legacy is very much your legacy as well. And I thank you.
Good morning, ladies and gentlemen. We will now start with our first panel discussion, and it deals with the rights of the accused. We will first hear from Mira Tapuskovic, and she will be talking about the equality of arms. Mira Tapuskovic has been around for a very, very long time at the ICTY. She was vice president of the ADC-ICTY between 2003 and 2004 and has been working at the ICTY since 1996. She was a legal assistant and co-counsel in the Music case, co-counsel in the Radic case, and currently she is co-counsel in the Popovich case, and has also represented, the only woman to have been at the UNDU, a guest there, Jelena Rasic. She was lead counsel in that case. In addition, she has been on the executive committee for several years. She was also on the disciplinary council and on the amicus committee of the ADC-ICTY. We will then hear from the Honorable Right Lord Ian Bonamy, who ran what I would consider the rocket docket at the ICTY. Anybody who appeared before Judge Bonamy had to move very quickly, very efficiently. Lord Bonamy has been practicing as a solicitor advocate and Queen's Counsel since 1968 and has served as senior prosecutor in the Supreme Courts of Scotland between 1990 and 1996. He was appointed judge of the Supreme Courts of Scotland in 1997 and has sat in civil and criminal cases at first instance and on appeals. Between April 2004 and August 2009, he was a permanent judge at the ICTY and a member of the trial chamber in the case of Slobodan Milosevic. He was presiding judge in the Milutinovic and 5 other Serbian politicians and military and political leaders, a trial that went on for several years. He served as judge of the Court of Appeals of the Supreme Courts of Scotland between 2009 and 2012, and he retired, unfortunately, because he's a fine judge, in October 2013. He currently holds a part-time appointment as Surveillance Commissioner for the UK, supervising the deployment by policy and other law enforcement agencies of intrusive and sensitive surveillance techniques. He might be needed in the United States. He is a chairman of the working group for both the ICTY and in Scotland, considering what improvements might be made in the practice and procedure for serious international criminal proceedings, producing various reports and recommendations. We will then, and by the way, Lord Bonamy will be talking about the right of confrontation, one of our favorite topics as defense lawyers. And then we will hear from a distinguished lawyer, advocate, both at trial and on appeal, and that's Christopher Gosnell, and he'll be talking about the right to appeal. And most recently, Chris was on the Taylor Taylor appeal. Chris comes to the ADC-ICTY as the vice president, currently serving as vice president, and he also served on the amicus committee. He has held positions of legal officer in the chambers at ICTR between 2003 and 2006, as well as the office of the prosecutor at the ICTY, for which we'll forgive him, jokingly, between 2006 and 2008. And since 2008, he has been a defense counsel. He was lead counsel in the Borovchin case. Currently, he's co-counsel in the Hodgetts case, and I believe he's also a legal consultant in for the Zupin case. And as I've noted, he was on the appeal of Taylor, but has also worked at the ICC in the Public Counsel for Victims section. Each panelist has 10 minutes, and I will act as Judge Bonamy would in his court. I would cut them off at 10 minutes. Then we'll have some questions and answers. Thank you.
No. I prefer sitting here. Good morning to everybody. I'll do my best to fit within 10 minutes, but it's not my brighter side. My subject is equality of arms. This is one of the basic principles and strict sensu that means that the defense and the prosecution must have procedural equality, equal access to the court. Since the creation of the United Nations, we are witnesses of a strong commitment to all human rights instruments, the Universal Declaration of Human Rights and others, and to the principle of fairness as well as the perception of the fair justice system. Today, we are not dealing with the equality of arms in general terms, but how that principle is implemented and how it functions here before the ICTY. The principle of equality of arms is a jurisprudential principle and is a part of the right to a fair trial. We just heard His Honor Judge Meron telling us a lot about the fair trial. What is a fair trial? It's to afford every party a reasonable opportunity of presenting its case under the conditions which do not place that party in a substantial disadvantage vis-à-vis its opponent. When that principle is violated, just when a party can prove that it has suffered irreparable prejudice, that substantial disadvantage exists and was proved. The strong link between the equality of arms and the right to a fair trial is an expansive institutional entitlement and relates to the structural independence of the defense. Equality of arms is crucial not only to protect the human rights of the defendants, but also to ensure the legitimacy of the courts themselves. Let's start from the ICTY rules, the statute and the rules of procedure and evidence, and other regulations. In short, the Article 21 of the statute prescribes all persons shall be equal before the International Tribunal. The accused shall be entitled to a fair and public hearing. The accused shall be entitled to the minimum guarantees in full equality, and so on and so on and so on. But in spite of the meaning of that principle, the equal access to the court from the defense point of view is double-folded. We have, let's say, in-court situation and out-of-court situation. How it functions in court situation. The ICTY jurisprudence shows the disparity between the theory and practice. The chambers define and apply the principle differently in the different cases. Usual issues raised before the chambers were number of witnesses and allocated time to present defense cases. The defense was on a regular basis limited with number of witnesses and time allocated to the defense. A strict mathematical equality would suggest that all parties should be allocated the same number of witnesses and amount of time to present their cases. Chambers have expressed disfavor with a strict mathematical approach and support the standard of basic proportionality. In some other cases, the chambers have applied the substantial disadvantage standard to decide claims of inequality of arms. But that substantial disadvantage standard is quite unclear threshold that is very difficult to satisfy. It was always up to the chambers to define, to evaluate what is disadvantage and what is substantial disadvantage. To protect human rights and fairness of the trial requires that all persons or defendants have effective access to legal services provided by an independent legal profession. The independence of lawyers means that they perform their professional duties without any improper restrictions, influence, inducement. When the independence of our profession is in question, I will tell you just one very interesting example. It's Rule 8 of the ICC Rule of Procedure and Evidence. The presidency, on the basis of a proposal made by the registrar, shall draw up a draft of Code of Professional Conduct for counsels after having consulted the prosecutor. The defense lawyers have no right to provide input into the prosecutor's code. This is certainly a lack of independence under the Council of European Guidelines. Now let's start from the ICTY jurisprudence. We have several cases. Perlic case, we have person from Perlic case, Stakic case, Oric, Tadic case, Karadzic case, and in majority of those cases, issues were number of witnesses and allocated time. But anyway, in Perlic case, for example, the trial chamber reduced the time already allocated to the defense. The trial chamber took into consideration the complexity and number of witnesses in determining whether the reduction of time would afford the defense a fair opportunity to present its case. The defense got 25% of time allocated to the OTP, and the conclusion was that defense was placed at a substantial disadvantage vis-à-vis the prosecution. The other issue in Perlic case was the number of material that each accused can translate through bodies within the ICTY. In Oric case, appeals chamber has found, it is very interesting from the defense point of view, the OTP has burden of telling an entire story, to present a coherent narrative and provide every necessary element of the crimes charged beyond a reasonable doubt. But defense strategy, by contrast, often is focused on targeting holes in the OTP cases, which may require less time and fewer witnesses, and this is sufficient to explain why a principle of basic proportionality rather than the strict mathematical equality generally governs relationship between time and witnesses allocated to the both sides. Karadzic case, it's something new, and in this case, the trial chamber allocated the same time for the defense to present its case as it was allocated to the OTP. But let's see how it functions out of the court situation, which is very important for the defense. Generally, the prosecution has more resources for work than defense. OTP enjoys the use of vehicles, drivers, investigators, interpreters, money, and all other resources, while defense teams are much more limited. The prosecution is permanently based in The Hague. Defense counsel goes back and forth. It is obvious an inequality in investigative resources. The OTP began investigations, one of the most important stages of the proceedings, years and decades before most of the defense teams, together with enormous teams of investigators, experts, and other supporting staff. You can just look at the demographic unit of the OTP. This is something that the defense can just dream of. The OTP is accommodated in much convenient working space. Let's say from 2002 to 2008, we were struggling for defense space in up to 50 square meters with 100 of lawyers and supporting staff. Budget of the ICTY is a very good example. For years 2004 and 2005, when we had several ongoing, very big and very important cases, defense budget at the ICTY was just a bit less than 30 millions, while the prosecution budget was 100 millions. That's my conclusion is that equality of arms should be considered much wider to include the equality of means, resources as well. The other rules of the ICTY are very interesting, that from my point of view violates this equality of arms. Directive on assignment of defense counsels prescribes limited time to prepare the case in pretrial stage according to the case levels, and co-counsel jumps into the case at the very late stage, just a few months before the commencement of the trial. Generally, the OTP has much easier access to the local authorities, to the archives. Access to witnesses is a separate issue. Whenever witnesses, if they accept to talk to us, we talk to them in some muddy places and cafe bars and restaurants. But OTP has his field offices, assistance of the police, local authorities. But from my point of view, there is another dimension of that principle. An example of that principle is the decision in Gotovina case. The member of the Gotovina defense team were under criminal investigation and criminally prosecuted in Croatia for acts performed in the fulfillment of their official functions before the ICTY. The prosecution never faced such a problem. Pursuant to Rule 29 of the statute, states are obliged to cooperate with the tribunal and any chamber's orders. In practice, it was extended to cooperation with the prosecution, but seldom and with a lot of difficulties with the defense. As it was said in Gotovina case and Rašić contempt case, members of the defense teams, even case managers, are the ICTY officer of justice. Such an institutional weakness can undermine the legitimacy of any criminal court over the time and affects its credibility. Thank you.
Well, Mr. President, Your Excellencies, distinguished guests, ladies and gentlemen, many of whom I hope I can still call friends. As a champion of the rigid application of time limits, often robustly challenged by members of the ADC, I stand here feeling utterly vindicated by the conversion of the ADC into dedicated disciples of time limits. The evidence could not be clearer. Not one speaker today will have more than 10 minutes, and some even 5. That's quite a short time. Mind you, and I'm thinking of no one in particular, Mr. Carnavas, there are those who can make 10 minutes seem like an eternity. It is always a pleasure to visit The Hague. There are many reasons for that, but I'll mention only 2 of them. The first may seem strange to you, and that's the weather. And I suppose I didn't choose a particularly good day as an example, but if you are surprised by that statement, you haven't been to Glasgow. I'm one of a very small number who come from a worse climate than in The Hague. The second reason is this. For any lawyer with an interest in international law, The Hague is the undisputed capital of the international legal world. There are countless international legal organs based in many different parts of the world, but The Hague is home to the principal ones and bears its status with dignity and distinction. Among those principal international organs, I count the ICTY and its various component parts, including the ADC. Those of you who were here during my time know the high regard in which I hold the ADC. It's therefore an honour and indeed a privilege to be invited to address this legacy conference. As an outside observer now, I am acutely aware of recent unfortunate events relating to the work of the ICTY and also the adverse criticism made of certain judgments. The tribunal has recently figured large in the minds of the international community, and that can be a cause for anxiety. However, the power of work done here by the tribunal since 1995, its positive impact on international humanitarian law and international criminal law, and its resilience as an institution are such that it will emerge from this difficult period and, in bringing its mission to a close, hand down as part of its legacy a foundation for the continuing development of international criminal law and procedure. And none of that could have been achieved without a stout, intellectually robust and energetic defence. That, Mr. Moderator, has been and continues to be your contribution to the ICTY and its legacy. Now, I turn now to the right to confrontation at trial, a key component of the adversarial process under which we appear at the moment to be condemned to operate in international criminal tribunals. Generally speaking, in any properly organised criminal justice system, the majority of accused are convicted. I say that purely and simply as a statistical fact. It's what you would expect of a rigorous system of public prosecution. So, statistically, the defence start at a disadvantage. In a well-prosecuted case, by that I don't mean an aggressively prosecuted case, but a sensibly prosecuted case, most interlocutory decisions tend to go the way of the prosecution. That's probably a reflection of the generally stronger nature of the prosecution case. Those facts of life, combined with the gravity of the allegations brought before this tribunal and the length of the sentences that may be imposed, place an enormous burden on defence counsel, who in addition do not set the agenda but must respond to the programme set by the prosecutor. You will never redress the balance entirely, but you can go some way towards that goal by challenge and confrontation. It may be the strongest weapon in the defence armoury. So how's this weapon to be deployed? Well, certainly not aggressively or obstructively. The words challenge and confrontation may sound aggressive or obstructive, both, I would say, negative qualities. In my experience, neither approach will produce positive results. Productive confrontation demands skill and guile if it is to achieve its objective, whether that be to obtain a favourable answer or to discredit a witness, or indeed to obtain a favourable ruling from the court. You must never lose sight of the purpose of the confrontation. You'll note from the examples I've just given that I give confrontation at trial a wide definition, extending not only to the application of cross-examination skills, but also to exercising powers of advocacy and persuasion. Confrontation may therefore be with the judges on issues of law and procedure and a witness on the defense, and a witness on the evidence. From neither can you expect to gain much by defiance or discourtesy. Let me deal very briefly with confrontation with the judge or judges, but in view of the time, I will say very little on this. It's my belief, expressed in this institution on a number of occasions, that one of the functions of defense counsel is to make the judge's job difficult. That's a subject that at your next conference I shall be delighted to develop further. But today, let me concentrate on confrontation in the conduct of examination and cross-examination. The starting point for the right of confrontation of a witness is Article 21(4)(e) of the Tribunal Statute, the right to examine witnesses against the accused. In the description of the points I should address prescribed in my invitation to the conference is a series of what are said to be obstacles to the exercise of this right. Changing rules and procedure, untimely and voluminous disclosure, irregularities in the preparation of witness statements, problems of dealing with adjudicated facts, inadequate investigation, inadequacy of prior counsel. Well, I recognize that rule changes and delayed and incomplete disclosure can place additional, untimely and often unnecessary burdens on the defense. However, some of the difficulties highlighted there I'm not really qualified to speak of, such as inadequate investigation or inadequacy of prior counsel. It's not something I've any great experience of here. The difficulties I do recognize mostly arise as a result of the size of the cases. You will never have the time you would like, in spite of the length of the trials we have, you will never have the time you would like to do the job the way you as a perfectionist would wish to. In the defense of accused before the ICTY, it is unquestionably necessary to identify and focus attention, effort and resources on what really matters. That's on the significant controversial issues. It's counterproductive to spend time exploring trivial inconsistencies, challenging the irrefutable and confronting the incontrovertible. Sometimes wise discretion decrees that you accept that the evidence is the evidence and that you must await final brief and closing arguments to put your gloss upon it. Where the trial chamber can see determined efforts by defence counsel to focus on the issues in dispute, the chamber will inevitably be receptive to applications for indulgence. Defence counsel may also strengthen their case for time for preparation for cross-examination by assisting the chamber in the pre-trial phase and indeed during the trial to draft bespoke procedural rules specifically tailored to the requirements of that case. Under reference to the rules of procedure and evidence, which give the trial chamber very wide powers to control the proceedings, astute counsel may, for example, suggest time limits for disclosure of witness statements under Rule 92 bis and ter. On the other hand, these two rules and the statements compiled under pressure, especially where they are an amalgamation of several statements by the witness, cobbled together, often at the last minute, can be very fruitful cross-examination material for counsel. So I urge you not to be quite so circumspect as in the past, perhaps, about your preparation. Sometimes the reaction to last-minute documents produced by the prosecution will enable you to focus on inconsistencies and omissions that, given time, would probably have been detected before the material was presented. These are but a few examples to illustrate the main point I seek to make. The right to confrontation is but one element in the scheme of international criminal justice. It must be seen and exercised within that greater scheme. The overarching principle is that of fair and expeditious trials. Fairness and expedition run hand in hand. Tribunal judges are conscious of the need to expedite trials. Once the process begins and the clock starts ticking, it will grind remorselessly to a conclusion. There's nothing to be achieved by defiance. On the contrary, there's a great deal to be achieved by cooperation. And because, as I believe, astute proactive cooperation of Defence Counsel with a trial chamber will provoke a positive response from the trial chamber and render its own rewards, cooperation should be seen not only as a good idea, but as a responsibility of Defence Counsel. Now, with that, I've come full circle. If confrontation is one of the foremost weapons in the armoury of the defence, then counsel have a duty to their clients to maximise the impact of confrontation by playing their part in a positive way in making the adversarial process work. The duties and responsibilities that go hand in hand with the right to confrontation are such as to make it difficult, if not impossible, for a self-represented accused to defend himself or herself adequately. Of course, whether international criminal trials should be conducted under the adversarial system at all is another major controversial issue, but one for another day. I wish you well in your deliberations during the course of today. Thank you very much.
I'd like to thank Judge Bonamy for those remarks about confrontation, and it reminds me that another vital element of functioning trials is collegiality as well as confrontation. And looking out, I'm deeply gratified to see so many former colleagues and friends from the different organs of the ICTY as well as other tribunals. I think this is the kind of exchange that is all too lacking from our not only professional lives, but perhaps personal lives with unfortunate and perhaps unintended consequences in the courtroom. If we could go to, hopefully not my tax information, but rather the right of appeal. Maybe you can go to, version 2, that's right. If we can go over to the second slide. Well, perhaps I should just do it without the PowerPoint. The first PowerPoint slide that I was going to show you, there it is. And if we can go to the second slide, you don't need me to tell you that both the prosecution and the defense have a right of appeal before the ICTY. You don't need me to tell you about the black letter law distinction between the standard of review of findings of fact and findings of law. And I won't try to do that in the short time available, but I will try to encapsulate what has been going on recently in the appellate practice of the ICTY, look at perhaps why this has been happening, and examine how it affects the overall fairness of proceedings. And if we look at the last 14 defendants before the appeals chamber, and I'm including the last 12 ICTY defendants and the last 2 ICTR defendants, we can click to the next. What you see is that we have 6 defendants out of those 14 whose convictions were affirmed and their sentences unchanged. That doesn't mean that there weren't necessarily grounds of appeal that succeeded, but at the end of the day, those changes were minor enough that they did not change the sentence. 2 accused had their sentences increased, and the average increase was 7.5 years. and 6 accused or defendants had their sentences reduced by an average of 23 years. Now, if we can go to the next slide, you'll see how that compares to domestic rates of reversal on appeal. The Chinese rate of reversal is 0.5%. In England, it's 11%, and in the ever litigious United States, albeit at the level that generally involves the most sophisticated and complex criminal cases, even there the reversal rate is 20%. And by the way, of those 20%, about half are remanded and half end there at the case having been disposed of by the appeals chamber. And I'm talking here about the first appeal, not a second appeal. Now, if we can just skip the next slide and go to the one after that, I don't think that these the statistics that the appeals chamber is substantially reversing about 60% of trial judgments necessarily reflects that the appeals chamber is highly interventionist or wishes to be doing this. But the question is, why exactly is there such a high rate of intervention by the appeals chamber? Why is it so dramatic? And we know the consequences of this for the perception of the tribunal. It has engendered controversy. There have been accusations that this is an usurpation by the appeals chamber of the trial chamber's functions. But I think there's a broader picture going on, and I think there are some factors that need to be considered. The first factor is that the law in international criminal cases is often still unsettled in very important and substantial areas. Aiding and abetting, the elements of aiding and abetting are still unsettled. The Paris Appeals Chamber significantly, let's say, changed the law, at least as it was established after Merksich. But it's not only that. There's also the question of whether or not civilians, a crime against humanity must be against civilians or whether or not it can be against combatants. And that was only settled in 2009 by the appeals chamber. There are many other issues that simply have not been adjudicated because there are so few cases and because this area of law effectively started in 1997. And you have trials, even the trial that I'm currently involved in, where there are legal issues that are simply unsettled as the facts are being adduced and the evidence is being heard. And that, no matter what the trial chamber does, leads to a situation where there's a high likelihood of a potential change on appeal. But it's not just that. It's also that there are extremely broad facts in most international criminal trials, and the indictments are what I would call sprawling. They're sprawling because there are many material facts charged, but also because just about every crime that has a chance of being successful is charged, and every mode of liability is charged. And how often have we seen, those of us who have been practitioners in large cases involving indictments that encompass years' worth of events, when you reach the submission of appellate briefs, or of the trial briefs, and the trial briefs are like two ships passing in the night, often filed at exactly the same time, and yet both parties have their theories as to what the focus of the case is, and therefore there's no clash often. Even when one reaches the oral arguments, there's a significant lack of clash. And the lack of clash arises because, unlike a domestic criminal case, there are a wide range of potential approaches to a particular criminal case. The consequence is that even with trial judgments that are extremely lengthy, indeed perhaps because trial judgments are extremely lengthy, the results come out of the oven of the trial half-baked. And I say that without any criticism to the trial chambers, which often go to great lengths to be as exhaustive as possible. But I think that many trial judgments are developed without a full clash of opinions between the parties at trial. And that requires trial chambers to come up with their best determination as they can, but without necessarily the type of clash which is supposed to happen in an adversarial trial, which is supposed to winnow down the issues so that when there is a judgment that comes out of an adversarial trial, already there is focus in the determination and the basis for the conviction. And then once that focus is developed at the trial, then the issues are narrow on the appeal. In developed legal systems with a third level of appeal, then the truly complex and difficult legal issues are winnowed down even further. Here, of course, that can't occur. Now, I was going to go through several slides to illustrate how the appeals chamber in particular passages has been interventionist, but I'll simply summarize it like this. The appeals chamber, on the one hand, says that it is very deferential to findings of fact by trial chambers, but that they will not be deferential to questions of law. That's easy to say. What about all the issues in between? And now if you look at appellate briefs, both by the prosecution and the defense, they're often framed as issues of fact and law. Why? Simply because that's the bridgehead to try to get into a lower standard and to a fuller review by the appeals chamber. And the in-between, if we can go to the next slide, one of the most notorious in-between categories that has been developed is, well, what we're discussing here is not factual findings by the trial chamber, but conclusions of the trial chamber based on their factual findings. Well, what should be the standard in that case? I mean, there you're talking about inferences drawn by the trial chamber rather than factual findings themselves. And in fact, what we've seen in several judgments, particularly in Merksich, is that conclusions, the standard applied to conclusions, is much lower than in respect of factual findings. And that leads to a situation where they are easier to overturn. A second category is what has been described as the approach standard. And this is what occurred in the Godovina judgment, where the appeals chamber says it's not necessarily that there's a discrete error of law in terms of an application of a legal standard to facts, but there's an approach that is objectionable by the trial chamber. And when that characterization is applied, again, the standard is closer to an error of law, even though it's not really an error of law. And then the third area, of course, is when the appeals chamber simply says there has been an error in the legal standard applied to the facts, and then, at least in theory, that is supposed to trigger a de novo assessment of the evidence. Now, if we go down to the 11th slide, which is titled Consequence of Errors of Law, I'm sure it will get up there. There, in the Merksich case, the appeals chamber tried to narrow down what could be looked at. And they said that in that, what would be considered on a de novo review of evidence is they would look at evidence referred to by the trial chamber in the body of the judgment or in a related footnote, evidence contained in the trial record and referred to by the parties, and additional evidence admitted on appeal. Still pretty broad, and I'd say they've certainly gone beyond that in many of their appeals judgments. And now if we can just go down to the last slide, I'll conclude by saying that we can't, as defense counsel, genuinely claim, given the statistics that I put on the first slide, that defendants in general have been disadvantaged by the rather interventionist approach of the appeals chamber. On the other hand, I think all of us who are practicing at the appellate level at the ICTY feel a high level of anxiety because it is an unpredictable process. There have been some big surprises going in both directions, and because to a very large extent, the issues are not winnowed down by the time we get to an appeal. It is, in a very fundamental sense, a second trial, albeit one that is more limited and constrained in its focus, but that often spills outside of the focus that we think is there. And that does slightly diminish, I would say, the effectiveness of the trial. Not necessarily the fairness, the effectiveness of the trial procedure as a whole. And I don't fault the appeals chamber for that, but it's because you have cases that are so large being funneled through a meat grinder that simply can't produce a product that's fully digested or, shall we say, delicious to the consumption of all of those who are concerned and vitally interested in these judgments. Thank you.
Is my mic on? I guess it is. Okay, now we have approximately 40 to 50 minutes for questions. So if you have any questions, please stand up. There are mics. Are there to stand up to the mic? Please stand up to the mic. Identify yourself, yes, and identify to whom you wish to pose the question. And questions, please, not statements.
Oh, no.
And short.
Good morning. My name is Shafiq Majdalani. I am attorney at law at Beirut Bar Association and now NVP at the Defense Office of Special Tribunal for Lebanon. I have two small questions, if it's possible. The first question is to the Lord Bonomi. The second one was supposed to be asked to President Meron, but he is not here, so I will ask it to any member of the panel who wishes to answer. Well, my first question is about Kosovo War. As we all know, war crimes were committed from both sides, from Serbians and Albanians, and also from others. You know about whom I am talking. However, only Serbians were sentenced for these crimes. The question I am asking it to you, Your Honor, not as a judge, former judge, just as a simple human jurist, isn't unfair. My second question is, the President Meron has talked about serving sentence in some states. Now, we are not anymore in 1993. Situation in former Yugoslavia has sensibly changed. Isn't unhuman and against the human rights to send people serving sentence in other than their countries, especially that many countries who have signed an agreement with ICTY don't have international standards in J. I would quote France, United Kingdom, where there is big violence in J. I would quote Italy, Portugal, and other countries. Isn't it time that this practice should change and those people, it's their right to serve sentence in their countries? Thank you.
Your Honor, go for it.
Well, I'll deal in a fairly limited way with both. Your first question about Kosovo ignores the fact, I think, that there were prosecutions involving Albanians, albeit no convictions, I think is the... Well, in fact, it's not a case of no convictions. There may have been several acquittals, but there has been some convictions. So it's not true to say that there has been nothing done in relation to any other than Serbs. So far as NATO is concerned, if that's the other organization to which you were pointing in that question, The matter was the subject of investigation, and that's the end of it as far as I'm concerned. I'm not in a position to say what were the rights and wrongs of the investigation carried out in relation to NATO, but we do know that at least it was the subject of some early investigation. On the question of serving sentences, I understand your point, even about the United Kingdom, because one of the accused from here suffered a very severe attack in an English prison. On the other hand, it's not clear to me where you're saying or suggesting that the sentences could be served and where the accused would choose to serve them. If you're saying in the country from which they came, there may be a time at which that's the right thing to do, but looking at the history up till today of all that's gone on since 1991, it seems to me we're not quite at the stage where it would be right for the accused, certainly in the ICTY proceedings, to be serving sentences in Yugoslavia.
Okay. Well, thank you for the question, and maybe next time we'll invite Madam Del Ponte, and so you can ask that question to her, the first one at least.
Cynthia Sinatra, counsel with many of you in Chelabici and Srebrenica. I want to ask Mira Topuskovich if she also remembers that when we arrived at the tribunal, as far as equality of arms goes, the defense room had no telephone, no copy machine, no computers, nothing at all in which we could compete with the prosecution. And it did take a series of, I think you said that we should not be contentious about this or argue, but I remember asking Madame de Sampaio in a kind way to settle this, but it took years and years for us to even get a copy machine. And so the equality of arms issue, I think, is still a very large issue between the defense, the prosecution, and the registry. And also, Judge Bonomi, you said that we have all of the evidence that we need from the prosecution when we get our discovery. The discovery is given to us in piecemeal, and very often even it is trial by discovery, because we don't find out the documents that we're missing until we have the witnesses testify. And that's why these are prolonged trials, because we do not have the evidence, and the evidence that we do get is sometimes summarized from the view of the prosecution. So we need the raw evidence. It takes really discovery by trial in order to get there. And Mr. Puskovich and I were in the Chelabici case, and Mr. Karnavas and I were in the Srebrenica case, so you do understand. And it's just not as simple as distilling it down to a 10-minute argument. We have had to fight very hard to have equality of arms, equality of appeals, and the fact that where our clients serve their sentence is depending on what kind of treaty is worked out between the United Nations and the tribunal. So,
Okay, thank you. Now, let them answer the question so we can have other, hopefully shorter questions.
yes.
May I respond?
Please.
Yes, Cynthia, I do remember that time when we opened the gate of this tribunal, and it was a very hard time. I can't say that it's better now, because there were too many lawyers in these spaces. I didn't want to take an example of my case, which I'm in Srebrenica case, but that equality of arms is really violated in this case, because in that case there were 46 different experts' reports from glass, ammunition, structure, buildings, genetics, whatsoever. The OTP has one member of their team for each kind of experts. At the other side of the table, there were two of us, lead counsel and co-counsel. that there's no equality of arms. Really, there is no equality of arms. That's the reason that I focus more on this out-of-court inequality of arms. But by the practice and by the following the jurisprudence, equality of all arms is procedural equality, that you have the same access to the court. But from the defense point of view, that's not true. It's much wider. Equality of resources and all the rest.
Well, I thank you. I think mine was a combination of too many questions, but if you have any comments that you would like to make on my statements, I would appreciate it.
Well, I would like to correct one thing. I don't think I said that the defence have all disclosure from the prosecution, anything but. It's certainly not my experience, and I think anyone involved in any trial here recognises that disclosure is presented in a very unsatisfactory way. The only significant point I was trying to make was that when the prosecution, in the course of a trial, thrust statements of witnesses at you the day before the witness gives evidence, there's probably, in most cases, more mileage in just accepting it and looking for all the holes in this cobbled-together statement than there is in trying to adjourn the case for things to be done more properly. There is a place, a time and place in this institution for just taking what's given to you and running with it. On the other hand, in the general overview of the way discovery is conducted here, I think it is unsatisfactory. I think the defence on occasions are not given the respect they ought to be in the way in which the material is presented. I think there are two sides to that story too, though. I think the defence in many instances demand and look for material which has got nothing at all to do with the case and don't content themselves in certain instances with identifying what really matters and getting what really matters. The system has grown out of all control here because there's so much material. Everybody wants every bit of press reporting that's been done on Yugoslavia since 1991. Can you imagine the volume that there is? How many times the name Karadzic might have been said if you were to put something into a search engine? But does it matter? You really have to, I think, cooperate with the prosecution in identifying what really matters. And when you show you've done that, I would be surprised if the trial chamber isn't compelled to be indulgent. That was the main point I was making.
Your Honor, I'm sorry, but I think it does depend on, when you say what really matters, it depends on what really matters to whom, at what point in the trial. But thank you for your indulgence.
Thank you for that excellent question or set of questions. I'm still interested to hear from Judge Bonamy when he talks about being nice to the judges. That's the part that I don't quite get, because sometimes when you try to be nice, you're still getting shut down. What do you do then? Especially for some of us who don't have the sort of personalities that just exude, lovey-doveyness.
I'll give you the names of 10 counsel in here. You can go and ask that question of later.
Okay.
Thank you. Sasha Obradović, Embassy of Serbia. Allow me firstly to congratulate Mr. Novak Lukic and all others from the ADC for organizing this conference, and also to express my gratitude to the Faculty of Law from Rotterdam as official sponsor of this event. Firstly, I would like just to make a very short comment to what we heard about the enforcement of sentences. I'm grateful for that intervention. I would just like to remind you that the prosecutor for war crimes in Serbia at this moment, to date, have 158 defendants, out of whom 70 have been convicted, if those 70 can serve their sentences in Serbia, in their country, in their own language, in the system of their own language, where their families can visit them. I think it is in accordance with human rights, and I can't see any reason that the others convicted by the ICTY cannot be in the same system. In addition, I think, thank you. I think that also I would like to tell that Serbia has an agreement on enforcement of sentences with the ICC, so I couldn't see any difference then between two systems. Now, I will ask two questions. The first one, yesterday the Assembly of the ICC has finished its 12th session amending the rules of procedure and evidence in relation to the presence of the accused at the trial. Namely, we got 3 inventions, all of them concerning the summons, the accused who are summoned to appear at the trial chamber and not to whom the arrest warrants haven't been issued. Namely, the first, that the accused can be temporarily absent from the trial under exceptional circumstances. The second one, that in the part or parts of the trial, the accused can be presented through the video technology. And the third one, that the sitting heads of state or government can be excluded from the physical presence at the trial and replaced by only by counsel during the trial. All of those 3 inventions, let's say, were based on 2 presumptions. The first one, that the detention is not necessary in the trials before the International Court of Justice, and second one, that presence of the accused at trial, as it is defined in Rome Statute as well as in the statute of the ICTY, does not necessarily mean a physical presence of the accused in the courtroom. That approach has never happened in the rules of procedure and evidence of the ICTY, and I'm interested in your opinion concerning many of the accused who voluntarily surrendered to the ICTY and were supported by the government either in the course of their surrendering or later during the provisional release through the guarantees of state and monitoring of their provisional stay in the country. And second question is concerning the accused who are acquitted. Namely, we have today several acquitted persons who spent several years in the detention of the ICTY. No reparations to them. What's about their human rights? Thank you very much.
Okay, Judge Bonamy.
The rule changes at the ICC may be influenced by the particular circumstances of the case in Kenya, I'm not sure. And I'm sure many people here will have their own personal political views about the rights and wrongs of trying a sitting state president. So I'm not entering into that territory. I think you have to, though, take account of the fact that in general throughout the world, accused persons are expected to be present at their trial. And if you're going to allow them not to be present, then it has to be done in a way that is generally publicly acceptable and doesn't just apply to the type of trials we are doing. Video appearance is, in my view, appropriate in the right circumstances, and I'm certain that in international trials there will be a place for it. It already occurs in European countries in relation to interlocutory hearings, appeal hearings. It's slightly more tricky where evidence is being given and judgments have to be made about the bearing of the individual. But indeed, in the Milutinovich trial here, there were a number of occasions when accused were not present in court. On an agreed basis, cooperation there was a high level of cooperation that led to that. Video recordings were made available of the day's proceedings that could be reviewed with the accused. So there are sufficient safeguards as long as it's something that's generally publicly acceptable, and we're not departing. I don't think you could argue that most people on trial in the world should not have to attend the court. As far as reparations for acquitted accused are concerned, the position is no different from that in probably the vast majority of countries. My own country, certainly in England and Wales, it's possible for the costs of proceedings to be awarded in favour of an accused person who's acquitted. But in Scotland, you get nothing, not even the expenses that you've incurred if you've had to pay for your own representation. So there's nothing exceptional, I'm afraid, about that. It seems to be generally acceptable and not a contravention of human rights. It's certainly never been seen as such by the European Court of Human Rights.
Next question.
My name's Jen Syverson. I'm researching at the University of Leiden. My question regards a brief statement on interlocutory appeals, and there was an assertion made that a well-prosecuted case, in such a case, the prosecution would win the majority of those. And my question, firstly, is just why, and whether the other panelists agree with this statement, particularly and what that says about a well-defended case, if the implication is that there should be a certain conservative nature to the prosecution's case and a certain more rigorous approach, challenging approach for the defense case with regards to such appeals. Thank you.
That statement was made in relation to all proceedings in general, not with particular reference to the ICTY, and it was based on and indeed you heard President Meron refer to it. It was based on the notion that a prosecutor is a minister of justice, and a prosecutor who prosecutes his case well will not argue against a decent defence submission, and will therefore have conceded anything that ought to be properly conceded. The defence, on the other hand, are up against it, in my view, all the way through, and the burden on them is entirely different, and it's one that results, generally speaking, in more issues becoming contentious than would be from the prosecution point of view. It just reflects the imbalance of the cases, as I see it, and therefore, in general, and I wouldn't be critical of the defence for the fact that perhaps they lose more than they win in interlocutory cases. If it's arguable at all, it's the duty of the defence to argue it. On the other hand, that's not the position of the prosecutor. He's entitled to take a reasoned decision about the prospects of success and to abandon his opposition. So, in my experience, that's what happens when cases are well prosecuted.
Thank you. Well, I've never seen a prosecutor abandon the position, but hope springs, eternal. The very last question, and we're going to shorten the coffee time because I was told to cut everybody off a while back. So, last question. Keep it short. Keep the answer short, please.
Thank you. My name's Nadia Shamsi. I'm a lawyer in Chicago and a student at Leiden University. My question is regarding the right to appeal. I was wondering if Mr. Gosnell would be able to, if he would be able to comment on whether the interventionist approach that the appeals chamber has is prevalent in other international criminal tribunals, or whether it was more the ICTY because it was one of the first international criminal tribunals.
Special court, very non-interventionist. Nothing reversed by the Taylor appeals chamber of any substance. I don't think there's a 2,800-page judgment that has not had some element reversed at the ICTY. The ICTR, of course, shares the appeals chamber with the ICTY. The ICC, I wouldn't really be in a position to comment, and frankly, there isn't a record yet of appeals from trial judgments to be able to say whether or not there is such a trend. The big issue is whether or not there's a mechanism to narrow the cases early on so that you don't have a situation where trial judgments of necessity are these sprawling beasts where there's an opportunity for substantial errors and mistakes because the parties aren't engaging on issues, and the trial judgment is sometimes creative in terms of making conclusions based upon matters that haven't been fully argued between the parties. The ICC purports purports to have a much more sophisticated process of narrowing down the charges. And of course, there are more interlocutories, frankly, at the ICC. So that may reduce the need or the extent of reversals from trial judgments, but we don't know yet.
But reflecting back, would you say that early on, the appeals chambers was very conservative, and it's only lately that they feel that they've sort of come into their own, where they're willing to take the right action, or to make the right decision, whereas before it was a given. You know, you came to The Hague, you're supposed to be convicted, the conviction is supposed to be upheld, end of story.
Well, maybe. It could also be that the defense bar has become a lot more sophisticated, with all due respect to the earlier cases, and I'm being sincere. I think we've learned. I think appeals are probably better crafted based upon what I've been able to see anecdotally, and also the law is less of a terra nullius. Now we do know what we can argue and what we have a crack at. Whereas back in '99, and there are others who are in a much better position to speak to this, maybe it wasn't so clear what matters were going to be successful on appeal.
Well, thank you. Thank you very much. And we're going to have a short break. It'll be shorter than scheduled.